doctor did not follow grievance procedures, did not exhaust his remedies, and what he seems to be arguing is that the contract wasn't strictly conformed to, which would have given him the right to grieve. I mean, that's essentially the way I understood the argument, and therefore the time frame for the claim gets collapsed, because when did he in fact get terminated? Because the termination should have come with the formal notice with a right to grieve. I think I'm restating his argument.
Right.
And as I look through the agreement, it's tricky as to what was required or what wasn't required. What triggered these events is, I guess, the question. You were going to answer it, I hope. Right.
Right. And so, well, the SUNY contract does provide, as you noted, that a notification needs to be given by November 15th.
Right.
And SUNY, as successor to Litch, relied on the documents and assumed the notice that was given on November 15th the prior year by Litch. And these are all sort of the same. These are all the same doctors, all the same faculty. There's no reason for them to revisit their opinion, which was final and conclusive on November 15th, as reflected in the record at 1:15. Going back to the...
He would argue, well, that notice is in a sense defective because it didn't advise him sufficiently of his rights to appeal and the like under the Litch contract. If you're assuming all of the actions of Litch, then in a sense are you...
The Litch contract, he actually said something around page 200 in the record, which is actually Litch policies and not the Litch contract, which appears on page 56
Right.
of the record. And if you look through the contract, 56, 57, you won't find anything about notice or non-renewal. You will find a provision stating that any dispute concerning non-renewal shall be resolved in accordance with the collective bargaining agreement, and that's the sole and exclusive remedy. So he's drawing on policies that are not incorporated.
Your
into
position
the
is the document at 115, which says, at this point he will not be offered a contract for next year, is a definitive statement, and that what he should have done then was, following the collective bargaining agreement, once the term was over, start the grievance process.
Correct.
Is that your position? I just want to make sure.
That is our position. And even if it wasn't, then in February he got another evaluation that he also could have challenged through the grievance process, and he didn't do that. And even in the last few weeks of his...
It doesn't matter, saying your contract will not be renewed, and therefore that would have started his rights under the collective bargaining agreement. Is that required, or is that not necessary?
Well, under the Litch contract, it's not. Under the SUNY contract, as you noted, it says that notice will be provided by November 15th, which it was, in accordance with the Litch notice that was given on November 15th.
These conditional notices, quote unquote.
It's conditional notice, which we contend is not a conditional notice, but a firm notice.
At this point, he will not be offered a contract for next year.
Yes, that's at this point, November 15th, which is when the collective bargaining agreement requires also that notice be given. At this point on November 15th, we decide that your contract will not be renewed. Trying to get his performance to improve, because he is there for another 6.5 months, they do want him to get credit for the year and provide good service to the patients in the hospital.
So has his time to grieve expired? Is there, I mean, because...
Well, yes, his time to grieve has long
in the
expired.
collective bargaining agreement, is there...
I mean, the collective bargaining agreement is, once his contract is over, it's no longer binding. So that's why the first 3 claims that all concern time during his residency are barred by his failure to exhaust administrative remedies.
How do you deal with the defamation claim then, which he said he became aware of once he became aware of the Department of Labor documents, which I think use the word, one uses the word terminated and one uses the word fired.
Right. Well, as a
And when did they first become aware of those were at a much later point in time? Would those be timely just using those dates?
well, he alleges times frames within the 1 year period for a defamation claim. They're still not timely under the Court of Claims Act, which requires 90 days. The latest date that's referenced in those claims is October 2013, and he did not file his claim until April 2014. So they're untimely under the Court of Claims
What was
Act.
the October date, counsel? I apologize.
October 2013.
So if
That's on page 52 of the record.
Right,
That's in the fourth claim. The fifth claim doesn't allege any accrual date.
his best reading is the claim arose in October of 13, November, December, January, so he's only 4 or 5 months beyond the time frame to file that claim. Am I doing the numbers wrong?
That sounds roughly correct. We don't primarily rely on the timeliness argument against
Right.
the defamation claims. Our primary argument is that he has not identified a recipient of the communications, which is a pleading requirement that he has to make. And the fact that
You're saying because it's an internal Department of Labor document, they have no proof that anybody in the world actually read it or heard about it, and therefore, if it is defamatory, it was never published.
right, it's within the state of New York, and well,
They don't allege publication, they alleged internal publication.
they allege internal publication. For the Department of Labor Reform, there's the qualified privilege issue that Justice Barros talked about before, which there's no allegations of malice at all. If you look in the proposed claim in 5152, which is required to state to get over the bar of qualified privilege. The recipient, failure to allege a recipient goes more towards his claims about these purported statements to 150 residency programs where he doesn't identify an actual recipient of the statements, or even allege that any of these applications really got to the stage that they were promising enough that
I thought he alleged maybe that when potential,
you have to identify.
not alleged that, am I making that up?
Well, I think I says 150 residency programs, something to that effect, which is not enough. It has to be a specific recipient that received the statement, and there's some Second Department case law cited in our brief on that. And his argument.
Your argument essentially on the defamation claim is, forget the timeliness. It doesn't state a claim, and therefore that's his entire basis for a court to be able to say, we're not going to waste everybody's time and allow the claim to go forward because it has no merit, essentially.
Well, the late filing supports the Court of Claims' discretion in denying a late filing, but the more predominant factor is the appearance of merit and the failure to state a claim under which it would be futile to allow it to proceed.
We look very closely, as I'm sure everybody here has, at 3016, which is the CPLR provision on what causes of action you have to plead with particularity. All the statute says, as far as libel and slander is concerned, is that there be to whom, circumstances of publication and so forth. It seems as if it's the case law that took this rather simple language and then developed it into this much larger requirement for particularity.
Right. Well, you're right. That the case law talks about the factor of the recipient, but even under 3016, which discusses the words, the allegations are mainly based on the contents of this internal house form that's used for internal purposes that there's no evidence that this form is used to provide references to other residency programs, and that it's not for internal payroll purposes, as the Wadowski affirmation states. So yes, the recipient is a creation of case law, but the defect in CPLR 30016 is also present here. And I might have mentioned this before, but I did want to emphasize that the fifth claim for defamation is jurisdictionally barred because it doesn't reference the accrual date at all. Just have a couple words about the Mr. McDonald talked extensively about the standard of review, and the Court of Claims in its decision cited the standard of review. One of the prongs is legally defective, and that is determinative here because there's no point in allowing claims to proceed when they have no merit, when the allegations fail to state a cause of action. Unless there are any other questions.
Thank you very much. And thank both of you.
Mark?
I'm sorry, I'm Judge Barris.
There's another argument. Yes.
I'm sorry.
Yes.
We're not trying to jitter.
That's my case.
We figured
We've
so Litch still does exist then, I guess, if you're here, right?
according to Appellate, it does. But
Well,
as of May 20,
according to you, though, does your client exist?
there are no people. As of May 29, 2011, there was absolutely no people that were Litch employees.
Right, but it exists still as a corporate entity on that
It
date.
exists as a shell to handle claims that may have arisen before May 29, 2011. I believe there's two claims, this being one of them. As soon as those go away, I think the word Litch goes away. But there is no employee, no physical human being connected to Litch right now.
Well, you are.
It's true, Your Honor.
I get a heart attack right now. I don't go to Litch.
I wouldn't go to Litch. I think they've closed their doors. With the docket on number 9, there's a motion to dismiss based on the failure to give due process to the appellant. But it's, as we stated, or the other parties have stated, the Litch contract is fairly clear. I understand that conditional non-renewal, it says if you receive notice of non-renewal, that triggers the grievance procedure. You've got 60 days from that point to file your grievance. On November 15th, plaintiff received a notice, you will not be renewed. That triggers the 60-day grievance procedure.
But doesn't it say at this point? It's
At-
kind of ambivalent.
On this date,
And
at
it
this
gives you
point,
hope, like, at this point, but you have a remediation program that's going to kick in, and so,
doesn't say at this point, there's a possibility that it won't be renewed. At this point, we're going to consider not renewing. It says at this point, you will not be renewed. That's your notice of non-renewal. That triggers the CBA grievance procedure. Plaintiff, I guess, realized that and tried to bring in documents from 2003 showing a wholly different procedure. But as the Litch contract says again, it has a merger clause. Contains just the four corners of the contract and all the documents referenced therein. The 2003 bylaws that they tried to shoehorn their way into was not considered as part of the Litch contract. It superseded that. It didn't just supersede non-contradictory provisions or contradictory provisions. It superseded all documents. The only document relevant are the Litch contract and the grievance procedure.
So on February 9th, he received another another evaluation, which I guess your position is, it reconfirmed that he would not be renewed. It said, Dr. Golio will not be advanced to a PGY2. And then it says he will need to show improvement in order to get credit for his first year. And then his next notice,
The notice, a reiteration of that notice in February. And then it was a final notice saying, you've completed the requirements, but you're still
so
not.
did he have 60 days to grieve from the February 9th? Or would it have expired already because he didn't grieve the October? It's really, I guess, an academic point.
From October, but that's a point, Your Honor. In February, he still didn't grieve from the 60-day point. But it did start in February.
Anything else?
I do want to bring a notice regarding the existence of Lich. In appellant's papers before the court on the Court of Claims case, appellant does say Lich ceased business as Lich when SUNY took over the internal medicine residency program on May 29th.
What are you reading from exactly?
I'm reading from the statement of facts provided to the Court of Claims from appellant. Even appellant agrees that Lich ceased business as Lich when SUNY took them over. If it's clear to the appellant in the arguments before the Court of Claims, it should be clear before this court as well. As conceded by all parties to this suit, when SUNY took over Lich, it assumed all of Lich's responsibilities and liabilities. If
Else now that needs to argue? Anyone in the back wants to argue this case? Okay.